There's been quite a bit of reliance on Sabri and Salinas. Could you spend just a few moments giving us your argument as to why these cases aren't dispositive?
Absolutely, Justice Thomas. So if I could give you the one sentence that I think might be the most important in this court's precedents for this case. That's the very last sentence of Section 2 in Sabri at page 608. This is the paragraph where this court in Sabri rejected Mr. Sabri's spending clause challenge. He said that this legislation is coercive. This court said, no, it's not spending clause legislation at all. This is not Congress's attempt, 666 is not Congress's attempt to impose its will on states' choices about public policy. It's instead Congress's necessary and proper clause authority to basically target those who convert public spending into unearned private gain. That's the line that the Sabri court drew. And Justice Thomas, I think that is exactly the line, the framework that you should keep in mind when asking what is RLUIPA? Is it more like 666 where you're targeting actual federal dollars and cents? Or is it like true spending clause legislation where what Congress is doing is imposing its own policy choices on the state recipients of federal funding?
So I guess I'm trying to understand how Congress could have said it any clearer. I mean, to the extent that we're puzzling over whether or not there's a clear statement in the statute, it says a person may assert a violation of this chapter as a claim or defense in a judicial proceeding and obtain appropriate relief against a government. If that doesn't refer to money damages being brought by an individual for a violation of RLUIPA, what could Congress have meant by appropriate relief here?
I mean, we agree with you. We think it's clear, especially once you look at the definition of a government, appropriate relief against a government becomes, the word appropriate relief becomes clear in the context of who we're talking about here, which is individual officers. So we would agree. And
even broadening out the lens more, I mean, RLUIPA is applying to prisons in a circumstance in which the PLRA and other statutes make it very difficult for prisoners to get any other kind of relief. Right? I mean, they can't get injunctive relief in any sort of meaningful way.
I think they could. I think prisoners could get injunctive relief under RLUIPA, and we would say that's another form of appropriate relief. But I do think that damages are necessary to complement, especially for instances like the one alleged here, where there's a one-time abuse. I think it also comes up in cases of when claims for injunctive relief are mooted by release or transfer.
Or transfer, which can happen all the time.
Yes,
so
and it's very, very common.
And okay. You've said many times that this is an easy case, and I think it's because of the privity argument. I'm trying to kind of puzzle through it. The state can say no to the condition in this situation. It has notice. It's a part of the agreement that the state makes to accept the funds, so it can say no to the condition that it must follow RLUIPA. But then we have this other layer, which is the employees, I suppose, can say no to a state that has agreed to the condition. Right?
I think that's right. They have a choice whether to voluntarily accept employment in a federally funded program.
Against the backdrop of a clear cause of action against people in their position for violations of the law.
Yes, I think the statute is clear as day that it applies to individual officers, and in that context, appropriate relief clearly provides damages.
And don't we ordinarily hold people responsible, especially officials, for knowing what the law requires and following it?
I think that's generally a presumption that this court has endorsed, yes.
Thank you.
Thank you, counsel.
This court's cases go farther.
Can I follow up with that just on the facts of this case? Because as I understand your argument, we do have both notice and consent under these circumstances, given that these individuals as third parties are not just people in the world, they are employees of the recipient of federal funds. And so to the extent that the recipient of federal funds has made clear with the federal government that it's going to require its employees to comply with RLUIPA and not violate people's rights, then when those employees choose, consent to accept a job with that employer, they are thereby consenting to follow those agreements. Is that right?
That is exactly right. And I think that's why when this court has had these cases, Salinas, Dixon, Hess, Laudani, it's a whole line of cases involving officers, agents, employees, subcontractors, where this is chain of privity.
Yes.
Every time the court has I think, actually seen this. In Salinas said there was no serious doubt. This is not a hard case.
Because chain of privity is a classic contracts concept, so that even if you thought that contracts was governing this, we have individuals who, for example, I mean, I suppose, let me just give you a hypothetical. What if the prison in this situation actually appends to its employment contract all of the conditions that it has agreed to with the federal government? And of course, the prison can only operate under its employees' not direction, but because there are employees. In other words, the prison doesn't have its own activity. So to the extent that it agrees with the federal government that it's going to comply with RLUIPA, it's saying I and my employees, the agents that I employ, are going to do this. And so let's say the prison actually appends to its employment contract all of the conditions that the federal government requires for the receipt of federal funds. So the person who is choosing to be an employee is totally apprised of what it is that is required as a condition of employment. I understand your argument to be that that would be sufficient, even if we assume that there has to be notice and consent to satisfy any such agreement.
Of course. And I think what this court has said, if I could, in Russ versus Sullivan and then in Alden versus Maine as to state officers specifically, is when you go into this job, when you go into this line of work and you voluntarily agree to be an officer in a federally funded state program, then yes, you implicitly, you necessarily take it subject to the conditions that Congress has attached to the funds.
Can I just ask you, because it does seem to me that the core of this is how we characterize Yearsley. Is it a defense or is it actually conferring immunity? What do we do with the fact that in Yearsley itself, the government had waived sovereign immunity? That's my understanding. And so to the extent that that's the case, wouldn't we have a very odd scenario in which the contractor would somehow be given immunity, but the government itself wouldn't, even though you say the contractor's immunity is derivative of the government's?
This illustrates exactly the way it's supposed to work.
Okay.
So the sovereign waives its immunity in that case and accepts liability, as it must constitutionally for a taking, by the way.
Right.
But then you sue the federal government. Our friends on the other side haven't sued the federal government in this case. The whole game here is suing contractors to try and thwart the government's policies. And so, today, today it's a case about immigration detention. Tomorrow it could be Cunningham, in which the contractor was engaged in signing people up for subsidized insurance under the Affordable Care Act. If you name a government policy or program, it will rely on contractors, and I can find you somebody who would like to stymie the implementation of that program. So that is how we get back to the important interests at stake here. But to Your Honor's question, the government is free to waive its immunity all it wants. The question, however, under the common law, and the long common law tradition, is that when contractors are performing as directed, that they are immune. And that makes sense. I mean, you should actually want to focus the litigation on the decision maker.
No, I understand, but you can do that by treating it as a defense. It's just odd to suggest that in a derivative sovereign immunity kind of that there is derivative sovereign immunity in this kind of circumstance. I mean, yes, to the extent that the contractor is saying we were just following orders, the law provides an opportunity for them to defend themselves as a result of that, and I thought that's really the crux of what Yearsley is getting at. But as Justice Kagan said, that's a different concept than we should be liable, we are liable, but we are not going to be held liable because we have immunity.
It is a different concept, Justice Jackson, and it's an importantly different concept because qualified immunity could be a defense.
No, but it's an odd concept in a world in which the government has assumed liability.
So sometimes it has
scenario.
Sometimes it has and sometimes it hasn't. In this case, the government has not waived its sovereign immunity as to the administration of these programs, which is why they've sued us. The government runs the exact same programs at its facilities. It's Section 5.8 of the PBNDS, which is the voluntary work program. Congress appropriates exactly the stipend that GEO pays. It's at PEDAP 141 and 144 is the disciplinary scale that comes from the government. It applies to their facilities too. So all of these decisions are made by the government, which is why I think Your Honor makes a good point that the suit should be directed against the government.